Okay, and everybody else will trickle in and start joining us. So I will stop sharing my screen. I'm the Executive Director of TI Canada, James Cohen. I'll join everybody again at the end of the call, but for the moment, I'll hand things over to our Chair and President, Susan Cote-Freeman.
Hello, thank you very much, James, and hello, everybody. Welcome back. This is day 3 of TI Canada's Week of Dialogue. Bonjour à tous nos participants et un gros merci d'avance aux panélistes qui sont avec nous aujourd'hui. Today we're going to continue exploring our theme for the week. It's a question, in fact, that we asked, and it's what's wrong with Canada? Are we taking anti-corruption seriously enough? For those of you who are joining us for the first time today, on Monday we started by taking a sort of more general view of Canada's anti-corruption performance. And yesterday we took a deep dive into Canada's institutional framework. A lot of gaps were identified in relation to Canada's poor enforcement record, anti-corruption enforcement record. We talked about new models such as UPAC and the Ontario SFO as potentially promising. But we also talked about issues of talent and expertise retention generally in the investigation sphere, the high bar for proving crimes. We also heard of other obstacles such as low penalties that are not sufficiently dissuasive, the current number of low convictions, the lack of incentive for whistleblowers were also mentioned, as was the lack of a beneficial ownership registry. So this is just to give you a flavor of what was discussed yesterday. We're going to come back to every day's discussion on Friday to sort of wrap it up and draw some conclusions. But today we're going to take a closer look at Canada's legislative and regulatory toolbox. And we're going to try to analyze whether it's sufficient, and if it's not, are there new tools that are needed? So I really look forward to today's discussion. Now, this is the moment every day where I thank our donors. So thank you to our Platinum supporter, Export Development Canada, our Gold supporters, BLG, Blake's, Banque Nationale, Deloitte Canada, Dentons Canada, Sky Power Global, and Siemens. And our Silver supporters, ACFO, Alessa, Kinross Gold, KPMG Canada, Thales Canada, and Groupe Vidocq. Now, I also make this plea every day. I encourage you to become a TI Canada member or supporter. You can donate by visiting our website at transparencycanada.ca. We need your support more than ever now. In these pandemic times, as you may imagine, things are getting difficult for many organizations, including ours. So your support would be much, much appreciated. Now, a quick housekeeping note. We're doing this meeting in webinar mode, which means you can't raise your hand to ask questions. So if you want to make comments, please feel free to do so by using the chat function. We encourage you to ask questions. If you want to ask actual questions, do it through the Q&A function, and our James and our moderator will be monitoring the Q&A function. So this takes me to the introduction of our moderator for the day, who is Anthony Cole. Anthony is a litigation partner with Dentons Calgary office. He co-leads the Canada Region White Collar and Government Investigations practice. Anthony acts for clients on internal investigations and actions by financial crime regulators and law enforcement bodies. He also assists with compliance reviews and risk mitigation programs. He's also litigated financial crime matters, including alleged corruption of public officials in civil courts and in investor-state arbitrations, in addition to being a certified anti-money laundering specialist. And last but not least, Anthony is the current chair of TI Canada's legal committee. And he's also a solicitor in good standing in England and Wales, having practiced in London before moving to a very cold Calgary a few years ago. So Anthony, welcome, and please take it away.
Thanks very much, Susan, and hello, everyone. As Susan mentioned, the discussion over the last couple of days has focused pretty heavily on the ways in which Canada may be falling short in terms of tackling corruption and money laundering. And in what may well become the defining image of this this week of dialogue, the analogy was drawn between Canada and a car that has all the functioning parts but moves extremely slowly. Today's panel, as Susan said, is going to look at what might be missing from Canada's toolbox, that is its legislative and policy framework around anti-corruption and anti-money laundering. And continuing the car analogy, is it just a question of fine-tuning the parts we have, or is it a more fundamental issue of replacing something or one or more things entirely to make sure all the other parts are in a position to function much better? The esteemed team of mechanics performing the diagnostics today are my panelists, Jessica Tillipman, Kim Manchester, and Amee Sandhu. And before we dive in, I'm just going to give you a little introduction to each of them. So Amee is the principal of Lex Integra, and she practices in the area of business law and corporate ethics. Prior to founding Lex Integra, Amee was senior legal counsel and integrity officer for many years in the engineering and construction sector. She currently teaches business law to undergrads and mentors young and future lawyers. She is also, importantly, a member of Transparency International Canada's board of directors. Kim is the managing director of ManchesterCF, a Toronto-based firm that provides online financial intelligence training to financial institutions and financial intelligence units and law enforcement agencies around the world. He's also a well-known commentator and contributor to discussions on AML issues. And then Jessica Tillipman is Assistant Dean at the George Washington University Law School in DC, where she teaches a course in anti-corruption and compliance. She's also a senior editor of the FCPA blog and a co-chair of the ABA International Anti-Corruption Committee. So we're very fortunate to have these esteemed panelists. And without further ado, we'll dive straight into to our discussion today. If Canada, again, without wanting to belabor this car analogy, but if Canada is a Ford Escape with potentially a misfiring engine, the US is undoubtedly the Mustang Shelby GT of anti-corruption enforcement. So as a starting point, in terms of what Canada might do to plug gaps, I'd welcome insights from Jessica on why the US regime has been so successful, at least in relative terms, and is the sort of undoubted leader in terms of anti-corruption enforcement over the past probably 20 years or so.
Thank you, Anthony, and thank you for TI for inviting me here today. I'm thrilled to be here. So first, when we think about success, and I think I agree with your statement in relative terms. So if we look at it in terms of enforcement numbers, and then also to me, I also looked at the fact and changed corporate behavior when it comes to compliance, because I do think the FCPA has had a significant impact on the way that very large corporations and even medium-sized corporations do business when it comes to compliance. So why have we been successful? Let me be clear at the outset, we are not perfect. And so even though we have had a pretty robust enforcement record, it's not a flawless system. So I can point to a few factors of why I think we've had such success on the enforcement end. First was the fact that we saw it ramp up over the past 20 years or so. I mean, we know that for the first 2 decades, there was almost no enforcement, although I'll tell you that Justice Department officials that were working there at the time have been on some of the panels that I've had at the school, and they get very offended when I say that. So I will say less robustly enforced the first 20 years, not no enforcement. But in the second half of the 40 years of the FCPA, we really saw a change when there was a greater enforcement priority. Post 9/11 in the United States, there was a greater connection between the role corruption played in terrorism. So there was definitely a shifting enforcement priority on combating corruption, of course, again, to deal with the terrorism issue that our country was suffering from and continues to suffer from at the time. So by empowering the individuals, and at the time was Mark Mendelson, when we really started to see the FCPA unit ramp up, empowering that team, giving it more resources, building it up, and making it a priority, we started to see that shift. So prioritizing and providing resources is probably one of the biggest factors. The second is we saw in the wake of the collapse of Enron, legislation passed primarily Sarbanes-Oxley in the United States, dealing with securities law, dealing with requirements for greater internal controls, and then also reporting requirements associated with those internal controls. And when there was an affirmative obligation on at least companies that are public companies in the United States that are issuers under the FCPA, when that became a requirement for them in the wake of Sarbanes-Oxley, we started to see greater reporting and, of course, greater potential liability for lack of internal controls because of it. A third, and I think probably if it's right up there with enforcement priority, would be the introduction of voluntary disclosures. There was a gigantic push after around 2003, 2004 for companies to come forward and voluntarily disclose their obligations, not only just some of the mandatory reporting requirements for the public companies, but also other companies, because the Justice Department was really promising tangible benefits to those companies that came forward. So we started to see an overwhelming number of voluntary disclosures, which to this day still feed the Justice Department the greatest source of its cases. We also saw the greater utilization, again, in the collapse of Enron and Arthur Andersen in the United States, greater utilization of settlement agreements like non-prosecution agreements and deferred prosecution agreements, increasing the likelihood that companies would, in fact, voluntarily disclose and would, in fact, settle these cases, giving the Justice Department a whole enforcement record with these settlements, which is where we get our statistics from. So with the introduction and very frequent use of these settlement mechanisms, we started to see our numbers go up significantly as well. I think globalization plays a big role. The government's had more access to information, whether it's tips or whistleblowers or information sharing among governments. I think that's played a big role. And of course, thanks to instruments like the OECD Anti-Bribery Convention and other sources of international cooperation, we've just seen greater kind of cooperation and information sharing there as well. So I think all of those play factors in why we've been so successful as defined, as I said at the outset. And some are greater factors than others, but I think those are the ones we can pretty much point to.
Thanks, Jessica. And I noticed there you mentioned the use of settlement agreements, deferred prosecution agreements, non-prosecution agreements. Canada's one of the biggest change to Canada's toolbox over the last couple of years was the introduction of remediation agreements, or Canada's version of deferred prosecution agreements. Could you explain why you think that the use of that, the use of DPAs, MPAs, had such a significant effect on self-reporting or voluntary disclosures and then extensive cooperation with law enforcement officials?
Sure. Well, for one thing, they provide companies with some level of certainty. You know, you're going into this process with the expectation that if you cooperate, remediate, and even voluntarily disclose that there's going to be, there's an end period to it. You'll pay a fine. You'll enter an agreement to, improve your compliance program, and there's a much greater level of certainty than if you're going into the government with the possibility of an indictment. Now, that's always hanging over a company, but it's just doesn't happen really in the United States anymore. So this desire to avoid potential indictment, which many people, although it is debated sometimes, maybe people point to the fact of indicting of a company is what basically puts them out of business, is the death penalty for companies. The concern over the, I'd say, uncertain outcome and the potentially disastrous consequences associated with an indictment compared with the much more certain outcome associated with an NPA or a DPA. Some people write it off as the cost of doing business, but companies have become much more comfortable with these settlement agreements over the years and are much more willing to engage in the process because of them. Now, whether that's a trend that continues in the long term remains to be seen, but at least for the past 20 years, that seems to be one of the driving factors.
Thanks, Jessica. I'm going to pick on Amee actually and get her perspective. I mean, based on Canada's version of or Canada's remediation agreement regime, we've had it for a couple of years now. We haven't seen one yet. We've seen one very high-profile refusal, but no DPA awarded yet. I mean, in fairness, anti-corruption investigations take a long time, but 2 years out, as I say, we still haven't seen one. Is there anything you feel can be done, Amee, with, or the use that can be made of remediation agreements that you'd like to see being adopted or utilized within Canada's remediation agreement regime to encourage some of the things Jessica's been talking about: voluntary disclosure, extensive cooperation?
Well, I think that the first thing that we would like to see, and by we, I mean, we've written about this within TI Canada's reports and FAQ on remediation agreement, another document, is we don't seem to have a kind of a guidance document issued by the federal government with respect to when they might be utilized, what kinds of responses from corporations they would be requiring, what they would be expecting in terms of cooperation, just any kind of a framework for companies to understand what it would mean to take this route. And I think from what we're hearing from Jessica is that this seems to be an area that is, well-trod ground in the US, and that there is a greater degree of certainty, or at least of what the process is, and then also what the likelihood is of a successful outcome once this process has been entered into. And I think in Canada, we just haven't seen that. There has been some kinds of information that has been provided, but as far as we understand, that was part of a desk book that was made available to prosecutors, but not something that has been made available to counsel who might be advising corporations or to corporations themselves, which would help them understand, what does this mean? What are the risks? How is this better for our organization than not entering into a remediation agreement? And also, what are some of the elements that would be taken into account to determine if this was a good outcome for everyone involved? So just in a high level, we just don't have enough guidance on how this can be made to work effectively at this time. Now, secondly, to your point, Anthony, it hasn't been that long, and the investigations themselves do take quite some time. And we also don't have much publicly available information in Canada with respect to how many investigations are started, how many are not concluded, and how many, eventually will go the full, the full litigation route. So it's difficult to even assess at this stage what the lay of the land is in terms of enforcement investigations anyway, much less how many of them may or may not be candidates for a remediation agreement. We just don't have enough information at this time, is the short answer.
Thanks, Amee. I'm going to shift slightly to the issue of proceeds of crime as a way of tackling corruption. And I'm going to call on Kim to do that. But before I do that, Jessica, I'm aware of the US Department of Justice kleptocracy initiative that's been part of the sort of anti-corruption enforcement framework there. Could you just give us a little introduction into what the US kleptocracy initiative, DOJ's kleptocracy initiative is, and how it's worked to date?
Sure. So this is a pretty impressive initiative from the Justice Department. It was launched in 2010, and it's basically housed within the money laundering and asset recovery section of the United States Department of Justice. It's designed to have dedicated attorneys, not only within the Justice Department, but also our Federal Bureau of Investigation and Department of Homeland Security, to work together to go after and target and investigate and prosecute cases of corruption, and to seize basically the ill-gotten gains of these corrupt foreign leaders. So I will say it has proven to be incredibly difficult to do these. So as easy as FCPA cases seem to settle, let me be clear, as a company that probably maybe listening that's maybe settled an FCPA case and probably doesn't think that process was easy. From a comparative standpoint, as easy it is to settle an FCPA case is as hard as it is to bring kind of an asset recovery case and how to handle these cases, which just take years and years and years and can be incredibly difficult, not only to get the actual hands on the money, but also due to a variety of factors, not only the difficulty in obtaining money in foreign jurisdictions, although there is somewhat easier likelihood to get it within the United States, but to seize assets, to have, because you need international cooperation to obtain the money. A lot of the individuals, as you can imagine, the kleptocrats that have these assets are able to hire the best lawyers. So they're able to pretty heartily fight these cases, which take years as well. But also, as we're starting to see that other countries are wrestling with, is how to return some of these proceeds as well. So that leads to other complications. But I would say if from the FCPA realm, one of the more famous activities of the Kleptocracy Asset Recovery Initiative, again from an FCPA realm, it involves Gulnara Karimova. And by the way, if I'm mispronouncing names right now, so sorry. My students actually laugh at me routinely as I butcher names. But I call her like the superstar of corruption. She's the daughter of the former Uzbek president, and just truly one of the most notoriously corrupt officials, and just a fascinating backstory on her too. But she managed to demand hundreds of millions of dollars in bribes from major telecommunications companies, VimpelCom, Telia, and MTS. This is in order for these companies to obtain telecommunications licenses in Uzbekistan. And then in addition to those companies, who are now all three on the top 10 largest FCPA cases list, because the bribes were so massive, our Justice Department's Kleptocracy Asset Recovery Initiative is also seeking forfeiture of more than $850 million of her money that she obtained in these bribes that's held in Switzerland, Belgium, Luxembourg, and Ireland. So you kind of see the interplay between the two. FCPA cases settled, and now we're doing the hard work of asset recovery. So that's just a brief explanation.
That's very helpful, thanks. So calling on Kim now. Kim, from a Canadian perspective, what do you see the scope for similar kinds of initiatives here, or the use of anti-money laundering laws in Canada as a means of addressing corruption, and in particular sort of the demand side, so the official side of corruption?
Well, we wrote an issue of ManchesterCF Analytics 9 years ago entitled "Corruption Needs Money Laundering," because the basic premise is you can't have corruption beyond a certain point without introducing the concept of laundering the proceeds of crime. A handful of banknotes, a Thai policeman, when I used to work for a British bank in Thailand, a Thai policeman had to purchase his own pistol. And so paying off the Thai policeman a handful of baht was necessary just to drive your car through certain checkpoints. But beyond that point, when you start getting into tens of thousands, hundreds of thousands, millions, hundreds of millions, then you get to a point where money laundering plays a massive role. And the whole money laundering architecture that works with transnational organized crime can then work with politicians, politically exposed persons, etc. And so in order to tackle corruption effectively, you need to have an architecture much like what Jessica's used to in the United States, where money laundering is considered to be a real hazard to a civilized banking society. And we need to introduce that concept into Canada. Our track record has been pretty awful, but the good news is, and I don't know why, that in a pandemic era, things seem to be looking up. We seem to be taking certain steps to pursue the subject of money laundering in Canada, and I think that's a good thing.
In terms of the framework as it stands, or at least the legislation as it stands, do you think that the framework is sufficient right now for that to be pursued, or do you think there are obvious gaps in the Canadian regime that would present an obstacle there? So
that's a great question. Framework. We have the Proceeds of Crime, Money Laundering, Terrorist Financing Act. And there's been some amendments that have come through as a result of various assessments done by independent third parties, the FATF Mutual Evaluation, Transparency International, the Basel Institute on Governance, all peering into the Canadian experience on combating money laundering and terrorist financing. there are elements of that architecture there that are world class. I mean, Canada was a founding member of the FATF back in 1989. But here we have a problem of regulation, a problem of enforcement, a problem of investigation. We discussed the car analogy before. You could argue that Canada is a good, solid, advanced BMW sedan, but there's no gas in the tank. That's the problem. And without that gas, without that impetus, we run into real problems. And the problems are best evidenced through the 2016 Mutual Evaluation Report published by the FATF, because in the annex in the back, it shows the statistics of prosecutions of 462.31 of the criminal code versus 354.1, which is possession of the proceeds of crime. 462 is money laundering. And we look at these horrific statistics in that report, since which have never been republished. Oddly enough, government not wanting to let the world know that we're not doing such a good job. So I would argue, yeah, the car is there. It's well engineered. It's in good shape. But can we put some gas in the tank, and not just regular unleaded? Can we put some premium in there, like above 90 octane? Because without it, what's the point? You know, without the banks, they're filing suspicious transaction reports. They're filing all the necessary bits and pieces, and it gets fed into the FinTrack machine, and out comes what in terms of prosecutions? Not much. So you want to pursue corruption? Terrific. In order to pursue corruption, you need to pursue money laundering. In order to pursue money laundering, you need to enforce what we have. We're not doing that very well.
Thanks, Kim. I think No Gas in the Tank sounds like a good title for the next TI.
I don't know how I came up with that on the fly.
So turning back to Jessica, just to tie off the issue that we've been looking at, you know, what the US has done well. I am aware that it hasn't been immune from criticism in terms of anti-corruption enforcement there. Could you just touch on what some of those criticisms are, so that when we're looking at the Canadian regime, we can keep that in mind and if necessary, sort of address that within any efforts to beef up whether the legislation or enforcement of it here?
Sure. Certainly, we've been criticized, and rightfully so in some instances, for some of the things that our government has done with enforcement. I'd say the biggest criticism we often hear in the FCPA realm is how the FCPA targets foreign companies. Sometimes even there's this belief that it unfairly targets foreign companies with no real connection to the United States. There's just a very tangential connection to the United States. There's a concern that this is a money grab on the part of the United States to effectively take all these proceeds from foreign companies, or to try to punish foreign companies, or to make them less competitive, or to go after competitors of US companies. So there's definitely those kind of anti-competitive arguments. The one thing I do want to say is, look at the top 10 of the FCPA. The 10 largest cases in FCPA history, 90% of them are international or foreign companies. Typically, there's been a connection through selling American depository receipts on the New York Stock Exchange. That's usually the connection of these foreign companies that land in our top 10. And so people point to that and say, well, this is the kind of FCPA out of control. This is the U.S. imposing its will on the rest of the world. Let me offer a modest defense of that, particularly if Canada ramps up enforcement against foreign companies as well, and starts to hear similar criticism. The foreign companies that are often in the top 10, first of all, look at the facts in the cases. The amount of corruption and bribery in these cases is massive. And so we do know that there is a relationship between the settlement amount and how much bribery is involved. I mean, Goldman Sachs, which just settled, which is a US company, by the way, it's $3.3 billion, but there was a ton of corruption, and we knew this large settlement was coming. Second, most of these companies don't have pre-existing or have lousy compliance programs. They're paper programs in place, which is why they haven't done as well when it comes time for settlement. Third, most of them don't cooperate, they don't voluntarily disclose, and they don't do as good of a job remediating. All of those are factors that the Justice Department considers when dealing with the amount of the ultimate fine or penalty. Many instances, these companies, their home country doesn't actively enforce it, so they don't see these kinds of statutes as a risk. And then oftentimes they involve senior executives or other aggravating factors. So that's just a modest defense to that criticism, which we do hear a lot. Another criticism we hear is what we refer to sometimes as the long shadow of enforcement. These cases take years to settle. Once you voluntarily disclose, you're going to waive the statute of limitations. You're going to have a lot of cooperation expectations on the part of the government, and it's going to take some time, some longer than others. But once you enter the system, it takes a while. So I think that there's some concern about how long these cases take once you're in the system negotiating a settlement agreement. Now, in some instances, they take what they take. The Justice Department doesn't want to necessarily settle a case. When you first come in, they want to make sure they've kind of uncovered the corruption, that they're not being duped into signing an agreement with leaving out really pertinent facts or other cases of corruption. So I understand.
So Jessica, just because I'm imagining a lot of the audience is Canadian, could you tell us, when you say a long time, in terms of the US justice system, how long are you talking about? And
Years.
because we have the similar situation, but then we also have a case law that came out a few years ago called the Jordan case, which now sort of really puts like a limit on how long things can take. So if you can just sort of give us fill that in a little bit for us, and sorry to interrupt.
No, it's not a problem at all. Walmart was a very long case, and I want to say it's more than 5 years, but somebody in the chat function can correct me on Walmart, but that was a very long case. Avon took a very, very long time. We're talking, could I give you an average? No, 3 years, 2 years, 4 years, but it takes some time, and some are longer than others. Does that help a little bit? But it's not overnight.
Yes, it's shorter. It's shorter for you. That I don't think anybody in Canada in this area would consider those to be long time frames, and I think we would consider those to be enviable time frames, unless Anthony disagrees with that.
Yeah. See, I can see the smile. I'd say 1 to 2 is would be somebody coming in and the government telling them there's nothing here and going away. It's definitely probably on the longer end of my assessment, but it takes years. So you have to keep that in mind. But of course, it sounds like that would be happy circumstance in Canada. So ignore that criticism then. One of the other big criticisms is the expansive jurisdictional theories that our government uses. So if you imagine that the vast majority of corporations settle these cases, they're not challenging the government's theories in court. So the government's expansive theories about who should be covered or the jurisdictional reach of the FCPA, that's what's going to control because it's not challenged. Now, increasingly, as the government continues to go after individuals pursuant to Justice Department policy that's encouraging the prosecution of individuals, we start to see that there's an increasing number of challenges to these theories because, of course, we know individuals have a lot more to lose than corporations, so they're far more willing to go to court and go to trial and test these theories. And let me be clear, in some instances, the government's theories have been rejected, but in a lot of cases, they've been affirmed by courts. So even though there's a lot of criticism about them being expansive, we've seen that there's been a willingness on the part of courts to accept a lot of them. Not always, but a lot of them. The one thing I want to also point out is I did notice from notes that we saw from James from the prior day that there was some comments regarding, I think what I saw, municipal or domestic corruption issues in Canada as well, that there's a concern of. Let me just say this, the United States has kind of been heralded and really kind of asserts itself as one of the global leaders of corruption issues. If you can't clean up what's in your own backyard, you can't be taken seriously on a global stage. Right now, the United States government is facing some of the worst internal and domestic corruptions most of us have ever seen in our lifetime. This current administration and our president has never before have we seen a president try to profit off a presidency like we're seeing our current president. And never before have we seen a president that has undermined ethics, has come out against the Foreign Corrupt Practices Act as a terrible law, has tried to do things that basically hinder corruption enforcement, and really has sent a message globally that this is not only not a priority, but something he actively abhors. When you have had a reputation globally as being a fighter of corruption, if you're not dealing with the message and what you're doing enforcement-wise internally, you can't effectively combat corruption globally. So I don't know how bad the corruption issues are in Canada. I can't imagine you're dealing with the same issues we're dealing with in our current administration. But I will say that the messages need to be consistent. Corruption can't be tolerated domestically as well as it can't be tolerated internationally. And the final thing I would warn about a criticism is the involvement of political interference in corruption prosecutions. 4 years ago, if you would have ever said to me, there might be potential interference in FCPA prosecutions, I would have laughed because the staff, the career staff at their Justice Department is so professional, and this is not political prosecutions. These people work hard, they take their job seriously, and they really have fine reputations when it comes to FCPA prosecutions. The injection of politics in our Justice Department through our current Attorney General, his involvement in prosecutions involving associates of the president, has truly undermined confidence in our Justice Department. And while I have no knowledge of and cannot even point to a single anecdote of political interference on our FCPA side, certainly we thought there would never be political interference in the way we've already seen. So there is grave concern about that. Should there be another Trump administration, and should we see continued political interference by senior leaders within our Justice Department? So I would also point out that political interference is a risk. It's a criticism of our DOJ. And as you're doing these prosecutions, that's something you should be aware of.
Thanks very much, Jessica. Now, there were a couple of things in there that I describe as potentially topical issues in Canada right now. So I'm going to kick it over to Amee first, and then invite Kim to add anything he wants to. But in terms of the Canadian regime and the criticisms that have been leveled maybe at the regime over the last few years, what sticks out in your mind, and what are the solutions?
Specifically on the last 2 points that Jessica raised, or just overall?
I think overall, but if you want to pick up on one or two specific points, that's fine. It's in your hands, Amee.
Well, I think that I would say that we have similar risks in every jurisdiction, and similar some of these issues have come up in recent times in Canada for sure with respect to allegations of interference in prosecutions, although I don't know that they obviously don't reach the level as we're seeing in the US, but we're a smaller place, smaller news cycle, potentially smaller stories get more media time. And other than what I've already said before about the time frames being different, I mean, that's the only significant difference I see, Jessica, between what you're describing in the US and the current situation / potential areas of risk for Canada. And I think that, I think a lot of people, a lot of us in many countries kind of do rest on our laurels, thinking that, well, we've solved democracy, we've solved rule of law issues, we don't have to worry about those anymore. And clearly, that's not the case. We always have to be mindful of those. But coming back to your question, Anthony, I don't think that in Canada we're necessarily at the point of discussing the issue that Jessica is talking about, because we're not there yet. We don't have a top 10 list of biggest corruption cases or enforcements. So how can we even talk about generalities? Like, what do we have? Top 4? Top 5? And the top 4 and the top 5 might also be called only 4 or only 5. So we're not in a situation yet where we can make generalizations, except to say we don't have enough enforcement. And I think that what I've noticed over the last few years is typically we've tended to focus on one topic or another topic with respect to, okay, this is the thing that we need to focus on to sort of get Canada on par with our trading partners that are good at enforcing corruption. But I think that now the time is here to take a step back and take a more holistic approach. What are the various elements that we need to look at in terms of the Canadian context? Like, I know for myself, I used to think it was more straightforward and simplistic than I see that it is now. And I think that one of the things that that differentiates us from the US, and I won't speak about what's happening in the US, is just the concept of criminal law and how we don't really have a due diligence or strict liability offense for corruption. It's, and then for the non-lawyers in the audience, basically what we have is the burden of proof and what it is that the prosecutors have to prove in order to get a conviction in Canada is at such a high threshold that it's very difficult to successfully get that kind of a conviction. And so one of the things we have to look at is that the best way forward? Do we keep that kind of a legal regime, hoping for the best, or should we be taking a look at other kinds of regimes? So for example, what you have in the UK with a topic, and Anthony and I have discussed many times, where in the UK, it's enough that the corruption has happened as opposed to looking at who was responsible for the corruption. And so this means that there would be, from a prosecutor's point of view, a lower threshold in order to get a conviction. Based on my experience working within corporations, I'm a big believer in the power of compliance programs and getting corporations to put in place all of the measures that they need to protect themselves from these kinds of occurrences. And I just don't think in Canada we have enough of a push for that. I've been surprised, not just at the number of times I've talked to corporations, but the number of times I've talked to sophisticated lawyers who don't themselves see the risk, or they themselves think foreign corruption is not that bad, or, well, that's just how you do business in other parts of the world. It's sort of, I keep checking the calendar to say, is this 2020 or like 1920 to have people say this? So I think that, you know, there's probably a great degree of public education that's required, or at least education among corporations and their advisors. I think we need to take a look at whether the legal regime itself in Canada is helping or hindering with respect to enforcement. And backing it up, we need to look at things like in the enforcement community itself, and I know this was discussed in yesterday's webinar and discussed in Monday's webinar, so I don't want to repeat it, but do we have enough funding to make sure that these investigations are taking place? And do we have the right kind of resources in terms of trained personnel who are staying within their units, whether at the prosecution area or investigations area, where they are spending enough time to really develop that expert skill set? And I'm not sure if it was Peter Dent who said this yesterday on yesterday's panel, but I believe he was looking at the Exporting Corruption report that TI International put out, Transparency International put out from Berlin, that was sort of looking at those countries that have, you know, or most successfully enforcing anti-corruption laws. And one of the people in the panel yesterday was talking about how they seem to have an expert anti-corruption unit of investigators that sort of is a standalone unit outside of like the federal police. So we don't have something like that in Canada, or if we do, it might not be at that level. I'm not here to criticize anybody, but I do think we need to take a look at, have we adequately resourced this? So, you know, to go back to Kim, have we put the gas in the tank to make these things happen? So it's a long answer. I've even forgotten your question, sorry.
Yeah, no, you did a pretty good job of answering it. I'm going to kick it over to Kim because I see he's eager to add his perspective.
Amee, I'm a big fan. Yes, yes, yes. I would go so far as to say it's time to introduce the Royal Canadian Federal Police. Within the RCMP, within specific units, there's a career path in order to gain promotion, which means you have to have a varied career involving various postings and various roles. And that pulls away from professional financial investigators who want to progress on a career path for promotion, to increase their income, to provide for their families. And so they'll dabble a little bit in anti-corruption and then they'll be pulled out. And they'll dabble a bit in anti-money laundering and then they'll be pulled out. And it's suicidal, it's terrible. But that's the way it's structured at present and is continuing to be structured like that. We have to change that. There are, and remember what I said earlier, there are indications that things are changing. Turns out our experience is, yeah, they are. And that there are movements within our national apparatus to concentrate financial intelligence expertise, but also across different forms, different government agencies. So the ACE teams, the Action Coordination and Enforcement teams for anti-money laundering, which by definition one hopes that creeps into the anti-corruption side. Those were introduced in the latest amendments on PCML-TFA. And those are starting to gather steam. Like it's kind of neat. And then the RCMP went through this horrible stage of, in the Peter German report, it came out that at one point in time in British Columbia, the RCMP were not conducting any anti-money laundering investigations at one point in time. Things have changed. I can tell you, they really have. And as a result, there's an increased focus to going back to the integrated proceeds of crime teams, integrated market enforcement, the integrated teams in general, which is tremendous. That's the way forward, because we have to get the pointy end of the sword correct in order to instill the fear of God into reporting entities about reporting money laundering transactions related to potential corruption cases or corruption cases in general. And that's, again, the car without gas in the tank. The ability to enforce anti-money laundering legislation on reporting entities in Canada, money services businesses, financial institutions, et cetera, et cetera. Oh, but don't do lawyers. No, lawyers, terrible. I mean, has anyone ever heard of a bent lawyer? No, never. So, maybe we should introduce that. I mean, other civilized countries have been able to do it. We can't. We have an ability to project this aura of, yeah, well, we know basically what we're doing, but we don't. And within the Five Eyes, the intelligence communities of New Zealand, Australia, Canada, the United States, the United Kingdom, we keep running into cases where $2 billion money laundering rings in British Columbia get dismissed because of incompetence or investigations that don't occur. We're going to get shut out. It's going to become the Four Eyes. And the inability of Canada to live up to what it's talking about is evidence when we lose a seat being bid on for the UN Security Council, when we're having great difficulty pursuing transnational organized crime and terrorist financing. Who are we to lecture people? And so we have to learn to walk before we can run. I totally agree with that. And that means going back to first principles on corruption investigations, on money laundering investigations, and the ancillary national security side of things, and saying, well, hang on, are we doing this right? Is the legislative construct correct? You know, Hong Kong merges possession of the proceeds of crime with the money laundering charge. That is taking 354.1 of the Criminal Code of Canada and merging it with 462.31. Could we do that? Yeah, I think we can do that. But it requires a national impetus to say, money is the lifeblood of corruption and of organized crime and of threats to our national security. Until we pursue it in a professional way that is at the level of our peers internationally, until we start registering those convictions, until we start looking at things like RV Jordan as toxic waste to the adjudication of law, then we have to say, right, well, we better get off our backsides and figure out how we're going to do this. And that I think is the first step. We got some serious navel gazing to do before we start making decisions on the finer points to what you were saying earlier. I really think we need to learn to walk before we can run. Wow, that was a speech.
That's helpful and valuable. There's a question here that I'm going to take the opportunity to fold in because I think it dovetails exactly with what Amee and Kim have just been saying. The question is, does Canada's anti-corruption regime suffer from a lack of economies of scale or critical mass? Perhaps that's why the car is so slow. The institutions are there and the tools are there, but an efficiency threshold has not been achieved. Thoughts? So I'm just going to
very quickly say no. Economies of scale, one investigator, one law book, one crown, one charge, one court. Economies of scale are not necessary when it comes time to financial investigations. You just need the impetus to do it. And I don't think it's a case of, well, we're too small. Other countries that are significantly smaller than Canada, Hong Kong's Independent Commission Against Corruption is legendary in its abilities to investigate and produce results. Hong Kong's not the same size as Canada. So economies of scale, no, we gotta have the will, the pursuit of it. When Bill Blair, after the British Columbia money laundering scandals came out, announced that money laundering in Canada receive, a few tens of millions of dollars over 5 years, you kind of look at that and think, really? So what's the point? If we're just doing chump change, it's not economies of scale, it's resourcing, it's money to fund regulation and enforcement and all the ancillary bits.
I would add to what Kim is saying is, have we looked at the coordination between the federal authorities and provincial authorities? I think that's an ongoing issue in many areas, but especially
Huge.
with respect to today's discussion, that to me is an issue, not economies of scale. I do want to say I don't agree with everything Kim said. I don't want to go on the record as saying that RV Jordan is toxic. I think though it would be better, like why can't we find ways to get the cases investigated and prosecuted faster within the time limits created by that case? Like that's something that escapes me, is do the cases take that long because they must take that long? Or is it because the teams that work on those cases don't have the expertise or resources required? Or is it because they're working on multiple cases at the same time? I don't have the answer to that question. I'm sure somebody in the chat group would or does know, but I do think that we should also be looking at our own standards, and do we accept that the cases need to take that long?
So a couple of things there. We've talked about some momentum behind enforcement. That would raise expectations, set the sort of the warning out there, would stop the conversations around, well, it's the cost of doing business, change that culture if there was a, momentum behind enforcement. We've also talked about the need for resourcing, including to, develop expertise. Kim talked about, federal policing agency that has a, independence and heavyweight presence to sort of force a mandate and isn't just going to, have its priorities directed elsewhere. On that issue of resourcing, the question for you, Jessica, is do I understand it correctly that the US model is somewhat self-funding in that penalties, settlement amounts are flowed back in, or in some measure applied to fund DOJ, SEC enforcement as well, or are the settlement amounts they're not used for or not directed back into investment in enforcement?
No. The DOJ definitely goes to the Treasury, so a DOJ settlement isn't going to go directly back into the DOJ. So that's one part. It goes to the Treasury, so that there isn't the incentive to try to prosecute a company in order to basically fund the DOJ. Now, I guess indirectly, yeah, it does go to the Treasury, so it's going to come back to the DOJ that way, but it's certainly not directly flowing back. The SEC has, there is some that comes from, some funding comes from their settlements, but no. So, I mean, yes, on one level, money comes back to the United States government as a whole, but not in the way that you described.
And from a policy standpoint, if I can put you on the spot,
Yeah, sure.
where would you sit on that? I mean, one, because the issue is allocation of budgets. There are competing budgets here, and white collar crime enforcement is typically not sat very high on the list of priorities of allocation of budget. So, what would your view be on some measure of a model that relies in some sense on the penalties being generated? I can see some problematic policy issues, but I welcome your perspective on that.
Yeah, I'm not a fan of that. I mean, one only need to look at the let's take a local level for people to better grasp how it could relate to them. The local police departments that fund themselves with tickets, or like parking and enforcement, or through civil forfeiture, the amount of the funding or other types of forfeiture that police departments routinely do to fund themselves. That's troubling to me, that you would need to bring an action in order to continue to sustain your own budget. I think it could lead to some negative incentives. I appreciate that you might have better control on some level over what you're spending the money on, but to me, that just, it leads to too much risk of abuse, of people trying to bring action and settle cases that otherwise shouldn't be settled or otherwise be brought in order to get the funding that they need. I like it to be, I like the fact that it comes, at least in our country, it goes to the Treasury generally. Now that taps into a whole bigger issue that people have complaints, and I guess I forgot this under my criticisms, is that the United States pockets the money instead of the money being returned to quote unquote victims. That could be a whole week-long webinar session if we wanted to talk about the returning of, or how to basic victim recovery of corruption funds. So to me, there are some interesting ideas there and some interesting proposals that have come along that talk about how the U.S. could use something differently. There's some proposed legislation, I don't think it's necessarily going anywhere, where 5% of recovery of funds from the U.S. Enforcement of the FCPA could go to a fund that could help combat, global kleptocracy and corruption and other sorts of things. So certainly there are some ideas on the table for that, but the idea of you funding yourself through your own prosecutions, I find troubling.
Kim.
Every single senior RCMP officer I've spoken to about this issue has told me flat out that in Canada, seizures related to criminal charges go to the general account of the government of Canada. That's the way it is, and that's the way it should be. Because if you change that, you then change the priorities of law enforcement to go after the biggest, flashiest fish, which is not necessarily the application of the rule of law. Please don't mess with it. It has its challenges, but if you start rewarding individual actions, you're going to produce some perversities of the implementation of justice. And I don't think that's a good idea.
So, I mean, I think the consensus among the panelists is that the government has to allocate greater resources, greater budget to this, come what may, proactively, rather than trying to create some kind of self-funding model for fairly compelling policy reasons. Amee, just turning back, and this brings in another question, about cooperation between federal and provincial agencies. There's a question here: how much can the Ontario Serious Fraud Office have this kind of impact? And I think by this kind of impact, we mean, changing the landscape, creating a momentum and powerful message behind enforcement.
Well, I think they can have a massive impact. And I was very happy to see that one of the panelists yesterday was from the SFO. To be honest, I don't even actually know that much about the SFO. I think it's a relatively new agency at the Securities Commission at the OSC, and I don't think that they've necessarily been quite public about, I'm sure they haven't done a marketing campaign announcing that they are there. So I cannot comment on what they're doing or how effectively they're doing it, but I do think that arms of the various provincial securities commissions have a big role to play. I'm assuming that they are all taking some kind of coordinated action, or at least doing coordinated policy setting and looking at what to focus on. And I would hope that there are some, there are better and better mechanisms to share the information if necessary or where needed with the federal authorities. I mean, I've been a lawyer for over 20 years, and I remember being in law school in securities class, talking about how the National Security Regulator is just around the corner. So I don't know if we're ever going to get there in Canada, and assuming that we're not going to get there, I hope that we have adequate measures in place for the various provincial organizations to be working together, but also having a good conduit to share information as necessary with their federal, not counterparts, but at least federal partners.
Do we, Kim, I'd welcome your thoughts on the sort of role of the Ontario Serious Fraud Office, or even provincial agencies in a particularly as relates to large scale. I mean, I think we've been talking about an appetite to see bigger and more significant anti-corruption, anti-money laundering enforcement. Is there a role for provincial agencies like the Ontario Serious Fraud Office in that, or does it have to be federal, because often you're dealing with cross-border issues? What's your perspective on that?
Well, okay, cross-border issues. As soon as a case goes seriously cross-border, generally speaking, it's handed from provincial law enforcement to the RCMP. That's been the general rule. Ontario's provincial asset forfeiture unit run by the OPP, we've worked with them extensively. They're great. They're really good. They're dedicated. They work hard. Giving them the ability to do more would be a great idea. The fragmentation of what we have in this country is too high. The lack of national coordination is too strong. This goes back to going back to basics. We have to learn to walk before we can run. So we can pretend to fund little groups and say, okay, you're going to go after this little thing here, and here's a budget, and here's a press release, go get them, Tiger. And then we can go after this little area here. But without a national coordination, a national understanding of financial crime, a mandate to go after corruption cases, a mandate to go after money laundering cases, then we're getting distracted. And I really think the impetus has to be, like, remember what Senator Gerstein put together as a report to the Canadian Senate, which was released the same day as the Canadian budget, which I'm guessing was done to maybe bury it a little bit. But in that report was testimony from officials across the land saying, echoing the title of the report, which was, is Canada's anti-money laundering regime working effectively? No, not really. That was echoed page after page after page. Individuals with considerable experience, domestic and international, stood in front of the Canadian Senate and said, here's a list of where we need to work harder. And we got to follow it. We got to put gas in the tank, and we got to learn to drive and without going off on the sidewalk or ending up in someone's bloody living room. The ability to concentrate on the basics and the fundamentals is what's going to pull up our ability to enforce anti-corruption legislation and the ensuing anti-money laundering legislation. And that's where I would stand on that point. I love the idea that Ontario's Serious Fraud Office is off and running. Great. I'm not going to say no to it. But what I am going to say is, why does that have to be an individual effort? Why isn't there a greater coordination? And don't, as we've said before in this panel, don't get me started on national securities regulators. 20 years ago, I mean, that conversation would have started well before then, and we're still zero, like zero. And we have equity market and capital markets problems here that are befitting a banana republic. So I think we need to get back into the driver's seat of working with what we have and making it more effective, which is enforcement, regulation, compliance programs. That's the basics, and we need to work on that.
So we're going to switch now. We've got about 20 minutes left before I hand back to James, but on the issue of compliance programs, we'll switch to that in a moment. But one thing I'd just say about the role of the Ontario Serious Fraud Office on international corruption, it's going to be a problem because the RCMP currently have exclusive jurisdiction on that, the ability to lay charges. So that would need to be changed. But just to wrap that up, on international corruption, do you think it's helpful to have a single agency responsible for the the investigation and charging around offenses like foreign corruption?
Well, sure, but we could, okay, so in certain jurisdictions like Hong Kong, you have the ICAC, Independent Commission Against Corruption. Corruption case comes up, it goes to ICAC. In this country, we can have corruption in Canada. I know, who'd have thunk? And that can be handled by municipal, provincial law enforcement. And then when there are branchings out into the realm of international transactions, yes, we need a federal police force to step in with its liaison capabilities in various jurisdictions. But the rules governing those relationships are not hard-coded. The operations governing those relationships are not hard-coded. There are tremendous rivalries between these different branches, and that is the current state of affairs as it stands now. and that needs to be re-examined. It's again cracking the nut of, well, what are we doing? How are we doing it? And are we doing it as effectively as possible? Because the end result is prosecutions. The end result is the perp walk. The end result is the mugshot. You don't think of Bernie Madoff until you think of his mugshot now. And so that's where we have to work backwards from that point of, we're definitely not achieving the end prosecution. So let's work backwards to figure out all the necessary corrections that need to be put into place in order to be at the level of our peers. Our peers are the United States, the United Kingdom, Australia, New Zealand, Europe, various other financial centers and democracies. And we need to get up to that level. So delineations between provincial and national law enforcement, sure, there needs to be greater concentration around that. But delineations on the application of law, delineations on how it's actually written, decisions on resourcing of whether or not this is something that causes us to say, well, corruption does have a cost to it. Money laundering does have a cost to it. And we're not prepared to pay that anymore. So I think it's a big issue that involves big discussions on big subjects, which means Crown Commissions deliberating this for the next 20 or 30 years.
So, and just, I'm going to call on Jessica really unfairly because it's an incredibly large, difficult question. But just from the US perspective, the SEC and DOJ obviously have key roles. Both of them have very substantial roles in FCPA enforcement. And if you can, in 2 or 3 minutes, just say it's totally unfair, just give a sense of how you think that relationship functions and whether it's a helpful thing to have, the two elements, the DOJ and the SEC working, often together closely and have that overlapping jurisdiction, whether that's a constructive thing or a potentially dangerous thing.
So I'm a big fan of overlapping jurisdiction when it comes to anti-corruption enforcement within governments, and not just from an FCPA perspective. I'm a believer that the more organizations that are involved, the greater likelihood that something will happen in case one of them drops the ball. So for example, and I'm just going to take a step back, we have numerous agencies within our government that provide oversight, whether it's our our Government Accountability Office, an arm of our Congress that provides audits, the agency inspectors general, which basically are the auditors within each individual agency. We have some that are dedicated explicitly to government procurement and defense procurement, like the Defense Contract Audit Agency. I like the fact that they all have overlapping jurisdiction and can sometimes supplement each other and work together. And because we know that if, for example, if one of the entities was to become corrupted, potentially another one can pick up the ball, or if one of them is, the enforcement is poor. When it comes to our debarment regime, if we know that one of the agencies has a weak system when it comes to excluding companies, we know that others can take up that challenge and handle that. So it gets considered, and we know that it's being handled for the most part. I think the DOJ and the SEC relationship is a good one. I think it's good. I think they work pretty well together. Now, let me be clear. I've never worked at the Justice Department in that capacity, nor have I worked at the SEC. So I'm not party to it. Is there probably some disagreement? Sure, I'm sure there is any time that there's a cooperation among two entities. But overall, I think most people would assess that as a relationship that works quite well. And we see instances where they can not only work together and often will settle cases in tandem, but their cases sometimes even when the SEC will go forward with maybe even something that's been disclosed to the Justice Department, but ultimately makes its way just to the SEC, where maybe there's a jurisdictional issue or maybe more difficult case for the Justice Department. So I think it works well, and I'm a fan of the way that it's set up. And I also just want to make one other comment. When it comes to enforcement, those are the two primary enforcers, yes, but when we talk about anti-corruption, it's not just those two entities. Anti-corruption issues globally can come out of the Treasury Department, they can come out of the State Department. We have entities throughout the government that are used to design to help globally, not only through policies and our policies abroad, but to help support the enforcement agencies in their work. So I think it's a package deal, and I think they all interact with each other to try to kind of achieve a common goal. Even when it gets a little messy sometimes, I think it overall works.
Great, thanks Jessica, that was really helpful. So now switching to the issue of compliance programs for 10 minutes. We did have a question earlier when Amee was talking on she mentioned the lack of guidance around the implementation of DPAs and the circumstances under which a company may be eligible or may expect to receive one, just to give that element of certainty that Jessica was talking about. It's worked quite well in the US in terms of encouraging voluntary disclosure and extensive cooperation by companies. The UK Bribery Act, you mentioned it earlier, has Section 7, which is a strict liability offence for failure to prevent bribery by associated persons, and it's subject to a due diligence defence, essentially, of having adequate procedures in place, which is a proactive incentive to implement a compliance program to get companies to have an effective compliance program up front, so that if something does go wrong, if an agent bribes somebody, they can say, well, we meet the threshold of having adequate procedures in place. Is that something you think is the most effective means of implementing that in Canada? Are there alternative approaches to incentivizing upfront compliance programs rather than after the fact remediation?
I'm assuming you're not specifically, like, you're limiting the question to whether or not we should have a Section 7 UK Bribery Act type of law here. My view is whatever incentives you need to have, you should have those in order to encourage corporations to have compliance programs, because the compliance programs, it's not rocket science, right? There's lots of guidance that come from all different jurisdictions. They all have very similar elements. And if you look at what the elements of those are, companies already have a lot of those elements anyway. It's just a question of making sure that they are broad enough to cover a variety of topics. For me, for a company not to have some element of those in the first place would be a big shock. They already have a lot of those elements. They just need to broaden them, make sure they're coordinated, and most importantly, operationalize them, right? So you don't want to have the paper programs that Jessica was talking about earlier. You need to have these policies that are actually so embedded into the fabric of the organization that the employees know about them and know why what the risks are. And then you have the controls set up to catch any activities that maybe the employees missed or deliberately missed. So if having a failure to prevent kind of a due diligence defense is the best way to incentivize corporations to put those programs in place, I mean, obviously that's a good thing. But one point I wanted to make before our time runs out is, I think one of the other issues that we have in Canada and that we haven't talked about today is that I think overall in Canada, people are quite naive and don't think that these are problems. Whether it's anti-money laundering, whether it's terrorist financing, whether it is corruption, domestic or foreign, I think that Canadians overall seem to have this sense that, oh, well, we're not like that, or we don't do that, or this is a problem that other places have that are not us. I can't go into why that might be the case, but I think that's one of the fundamental issues. And so I wasn't being facetious earlier when I said that we do need to have a bit of a communications campaign across the country. And, when you had the Panama Papers come out, and then you had the other papers whose name I can't remember, we've seen enough evidence that there are tons and tons of Canadian connections. You've got the snow washing. As someone in Ontario, I couldn't understand why nobody in Ontario cared about what was happening in Vancouver with the casinos, right? The fact that in Australia, they have named this model the Vancouver model is telling us that, look, if Australia is paying attention, maybe Ontario should pay attention. Why is there no coordination among the provinces to look at what's happening in our own backyard, even though it might be, a few time zones apart? And again, all I can attribute it to is, well, that doesn't happen here. So I think that whatever we can do to encourage corporations to put these programs in place is positive. But I think part of the bigger issue is that there just seems to be this either naivete or head in the sand, or ostrich syndrome, where individuals and corporations just don't see these as big risks. And to me, that's the big issue.
So,
if I could just quickly interject here. Again, Amee, big fan, thank you. I couldn't agree more. Time and time again, Oh, it doesn't happen here. What do you mean money laundering? It doesn't happen here. Terrorist financing? No. National security threats? What are you talking about? Stop being such a, you know, the earth is falling, the earth is falling. Give me a break. And the way you fix that, successful prosecutions, because it happens. Law enforcement knows it happens. You're talking about the British Columbia casinos. There have been major investigations into Ontario casinos that have fallen flat and getting thrown out because it's complicated, or no, we missed a few things here. It doesn't get picked up by Crown. So we have to get into the business of understanding that laundering money through Canada is a big business here, and there are vested interests that want to protect it. And we as a citizenry, we've got to stand up and say, no, the consequences of this are too much. It perpetuates organized crime. Organized crime kills people. So you have to be able to stand up and say, we have to investigate, we have to prosecute. And when those cases start to percolate, the attitude, the naivete that Amee mentioned will perhaps dissipate, because people will start to think, wow, it does happen here. Things actually happen here that are not good. And we better stand up to protect our civilized society. There are roles and responsibilities in maintaining civilized society, and one of them is the application of rule of law. And without that, with an airy-fairy attitude of, well, I mean, it's not important, it doesn't happen here, it happens elsewhere. That's insane, and it has dramatic consequences.
So I'm glad you went there, because I was going to ask you, Kim. Amee said she wasn't going to venture a reason why it's happening, but you've just done that. I'm going to turn it over to Jessica in a second, but just before I do, we've got the Cullen Commission in British Columbia now, the Anti-Money Laundering Commission. In addition to enforcement, do you think federal commission of inquiry into money laundering would be a good idea, useful way to?
I've spoken to the Cullen Commission. My first point to them is, why am I talking to you? Why is this provincial? Why is this not national? You know, do you want to discuss international politics at a local town hall? Or do you want to take this to the forefront of where it should belong, which is in Parliament, which is in the House of Commons, which is in our nation's capital? It's not just Vancouver. My God, it's not just Vancouver. It's Toronto, Montreal, Halifax, Quebec City. It's everywhere. So I applaud my fellow Canadians in BC for doing the right thing. And I condemn my federal politicians, bureaucrats, et cetera, for not walking in on day one and saying, you know what, shut it down provincially, let's yank this to Ottawa. We have to look at this as a nation. But might be asking a bit much. But it has to be federal. If it's not federal, it's a farce.
Okay,
not that I have a strong opinion on the matter.
Apparently not. No, didn't get that. Just on circling back to conclude on the compliance program issue, the proactive compliance program, Amee mentioned, we talked about Section 7 and a strict liability offence, which may have constitutional issues here as well. It's a complex legal question, but the US doesn't have a Section 7 failure to prevent offence, yet everyone accepts that they have been by far and away the most sort of quote unquote successful enforcer of the FCPA. So Jessica, from your perspective, how the US really encouraged it, very visible when a company has US connection, how much more they understand or are prepared to embrace very detailed compliance programs than companies from other jurisdictions. And I'm not just talking about Canada. Having practiced in the UK, the situation was similar there before the UK Bribery Act. They went that way. But what can you tell us about how the US enforcement agencies and the FCPA regime has encouraged proactive approaches to compliance rather than reactive ones?
Right. I mean, I think it's been one of the biggest components of it. We've been very visible on the importance of compliance. I mean, it started off being a portion of settlement agreements where, all of us that followed the FCPA would, dig through the settlement to see, you know, what kind of expectations did the DOJ have from that company when they settled in order to, from a compliance perspective. And so a lot of us kind of gleaned from both the sentencing guidelines, of course, but then also through the settlement agreements, what was the expectation? Well, then the Justice Department and in conjunction with the SEC and some other agencies came out with its infamous or famous FCPA guide. And in it created the hallmarks of an effective compliance program, which effectively outlined what its expectations were for companies. And this, quite frankly, mirrored what we'd already seen, a piece of the sentencing guidelines. We saw the guidance coming out of OECD, Transparency International, the UN. It looks a lot like what the UK has, but basically it looks a lot like what the expectations are. Quite frankly, a global expectation of what companies should be doing from a compliance standard. And that's what I do tell when I teach that in class, that really, you know, there are a few, you know, nuances depending on the country that you're most concerned about, although you should be concerned about all of them, especially if they have a more robust enforcement regime. But we all are really looking at the same things. We just call them different names sometimes or use different terms to describe them. So I really think that the US has had a huge influence on the importance of compliance, company investment in compliance. But let's be clear, it's not perfect. And one of my concerns, and what I've seen, and I will say I have less familiarity from a Canadian perspective, but I've seen other countries that have perceived lower reputations for corruption, like Canada, where maybe their governments aren't doing as much. I'll give an example. Australia would be one of them, the kind of a similar situation where they have a perceived low level of corruption in the country, but they haven't done as much enforcement under their obligations of this OECD anti-bribery convention. And companies there have a different approach. I've talked to people that come, you know, I've talked to anti-corruption professionals. I've talked to people that work in companies from countries like Australia, and there's this kind of lack of concern because their government isn't doing as much. So there just isn't the kind of commitment I've seen to compliance, or there's really kind of a check the box commitment. What's good enough to get us across the finish line? What's good enough to make it look like we're embracing compliance, even if we're not? And I do think that there is a real investment by a lot of large companies within the United States to embrace it. It's become an industry within the United States, I think globally too, but really in the United States, we just see a lot of compliance entities, organizations that offer compliance services, that offer to assist with the revamping of compliance programs, and a lot of thoughtfulness coming from companies that invest in compliance and take it seriously, and how they conduct their training and how to make it more effective and how to handle it globally. So I think it's had a tremendous impact on how we do it. I think the guidance helps. The one critique I have, and I know that this is a critique shared by others, is that there's been almost so much guidance from the Justice Department on what its expectations are for compliance, is that it can be confusing. So we have our guide, and then we have these kind of new iterations of kind of these compliance expectations that are released from the government. And it's helpful, and all the firms and entities quickly, you know, redline the old documents to find out what the changes are and what the new expectations are to provide guidance to their clients. And that's all well and good. You need to continually evolve your compliance expectations, but I do think it can be confusing and somewhat overwhelming to companies that don't know where to start or where to begin, and when it comes to compliance. So I don't want to say there's almost too much information out there, but there's certainly enough resources, and I think the DOJ's and SEC's insistence on these compliance overhauls and robust internal controls has played a large role in it.
Thanks, Jessica. So with 2 minutes left, I'm going to wrap up, but in doing so, I'm going to ask each of you in sort of one sentence, if you could urge the Canadian government, and maybe it's a provincial one, but judging by the comments, I don't think so. If you could urge the federal government to do one thing, or to focus initially on one thing as a priority, is it enforcement? Is it guidance? What is it? Amee, I'll start with you. You're on mute, Amee.
I know. I couldn't find the button. Well, because I know what other people are going to say, I'm going to say guidance. How about that?
Perfect. Kim?
Learn to walk before you can run. Get it right. Go back to basics. let's be an international. Let's participate at an international level with actions that back the theory.
And Jessica,
I'm allowed to be the American. I'm allowed to say it.
you are.
I hate your debarment regime. I don't think it works very well, and I won't go into more detail on that. You need to revisit
Well,
your debarment.
having teased that, do you mean the mandatory, the automatic debarment?
Yes, I think it leads to really unfortunate outcomes when it comes to your enforcement of other statutes because of the consequences. I think that there's a lot to be learned from how the U.S. does it and how it could really overall better affect corporate change and corporate compliance in companies than what you currently have.
We'll try and look at that as well. That's probably one for another session. So with that, very much to the panelists. Really appreciate your contributions, which were very much valued. And with that, I'm going to tip it back over to James just to wrap up.
Fantastic. Thank you very much, Anthony, for coordinating an exceptional panel. Thank you to Kim Manchester, Jessica Tillipman, and to Amee Sandhu for excellent insights from home and from across the border. There's nothing that motivates Canadians to act like being tisk by somebody from DC or New York or London. So if there were any federal officials who are attending today, we hope this may have encouraged you to act. We hope everybody comes back again tomorrow, where we're going to be looking at more overseas examples of what we can learn from other TI chapters and what Canadian institutions and companies are doing. I will once again thank our platinum supporters, Export Development Canada, our only platinum supporter, our gold supporter, Banque Nationale, Blake's, BLG, Deloitte, Dentons, Siemens, and Skypower Global, and our silver supporter, ACFO, Elisa, Kinross Gold, KPMG, Vidot Group, and Thales. We desperately rely on the funds from our members, and also our members to echo what they have heard here in the message of TI Canada, as well as the work of our supporters and our donors. So we certainly encourage everybody, please check out our website, make a donation. Normally the Day of Dialogue in Toronto is one of our big revenue generators of the year. Of course, we went online this year. This is all for free. So if you feel that it's warranted, you can make a donation or become a member or a supporter. Yes, I will keep up this message for the next 2 days. And we also do look at program funding as well. We have some programs that are funded, and over this week, I've heard some excellent ideas for programs, namely doing a deep dive investigation by TI Canada about what is wrong with our institutions and our programs to put a lot of what we've heard forward in a report. So if anyone's thinking about funding Canada to do such a report, we'd love to talk to you. So join us again tomorrow at 12 Eastern, where we'll talk about how we can actually address this problem that Kim has condemned the federal government for not doing enough about. And we look forward to seeing everyone tomorrow, and thank you very much for participating today. Bye, everybody.